Okay, we're reading contract overview. I'm really only on page 3, so we've gotten through just an overall statement of what it includes, whether it's UCC or common law analysis of the choice of law to apply, and are in the inquiry whether there's a valid contract, offer, termination of the offer, when it is an irrevocable or revocable versus an irrevocable offer, rejection and termination by operation of law, when destruction of the subject matter of the contract, supervening illegality of subject matter of contract, death or insanity of either party. Unequivocal acceptance in the acceptance section. Common law acceptance of each and every item of the offer according to the mirror image rule, whereas in UCC, an acceptance that adds terms to the offer is valid between merchants. The additional terms become part of the contract unless they materially alter the terms. The offerer objects and the offer is limited to its terms, which is referred to as the battle of the forms. Methods of acceptance. UCC reasonable means. Unilateral contract is by performance, and a bilateral contract is promise or performance, is how you can accept a methods of acceptance under those kinds of contracts. Acceptance is effective upon dispatch according to the mailbox rule. The limitation is the offerer opts out or the rejection is sent first. I might say received. The receipt of the rejection occurs before the mailing of the acceptance. Did I say that right? Consideration is the third part of contract formation. 1, bargain for exchange, not a gift, is a requirement. 2, a detriment to the promisee or legal benefit to the promisor, stands for consideration, and the courts focus on detriment. And then within that whole detriment or benefit, there's adequacy is generally irrelevant to the courts, and past consideration generally is invalid, and that is referred to as the pre-existing duty rule. Exceptions is when a written promise to pay time-barred debt, new or different consideration promised, promise ratifying avoidable obligation, for example, minor ratifying upon reaching the age of majority, compromise of honest dispute, unforeseen circumstances, make ratification fair and equitable. That's the modern rule, I believe, under the UCC, and or rise to the level of impracticability, which is the majority view, and then a good faith modification under Article 2. So maybe that's a modern rule under the common law, because then it says good faith modification under Article 2. Be nice if it was specific. Part D, must be no defenses to formation or enforcement. So mistake is the first defense. Then there's fraud and misrepresentation, illegality or consideration of consideration or subject matter, incapacity, which includes infancy, mental incapacity, intoxication, duress, and undue influence, and the statute of frauds plus unconscionability, where the courts may refuse to enforce to avoid unfair terms. Example, contracts of adhesion. I'm going to expand on mistakes. There's unilateral mistakes and mutual mistakes. For unilateral mistakes, contract is voidable if non-mistaken party knew or should have known of the mistake. Mutual mistakes, a contract is voidable by adversely affected party if 1, 2, and 3, the mistake concerns basic assumption on which the contract was made. A mistake has a material effect, and the party seeking avoidance did not assume the risk. Fraud and misrepresentation includes concealment and non-disclosure. That's really all I have to add to that part. Again, there was illegality of consideration or subject matter, there was incapacity, there was unconscionability, and then there's the statute of frauds, which is kind of like number 1 in defense to formation. Don't know why they have it as number 5. Certain contracts must be in writing, signed by the party to be charged. The examples go by the mnemonic my legs: marriage, year, land, executors and administrators, goods, and suretyship. So marriage, when marriage is consideration for a promise, example, if you marry my son, I will buy you a car. Land, promises, creating interest in land, leases, easements, fixtures, mineral rights, and mortgages. Year, promises that cannot be performed within 1 year of the contract. Land, again, no. Executors and administrators, promises to pay estate debts from own funds. Goods, contracts for goods of sale of goods for a price of $500 or more. Exceptions is specially manufactured goods, goods accepted or paid for. And suretyship is a promise to answer for the debt of another. Unconscionability, we read that. So what are the terms of the contracts? There's rules of contract construction. General rules: contracts are construed as a whole. Words are generally given their ordinary meaning. Written or typed terms prevail over printed. Custom and usage in business and locale is considered. Court will try to find contract valid, and ambiguities are construed against the contract's preparer. Parole evidence rule: when parties intend that a writing is the final expression of their bargain, no prior oral or written or contemporaneous oral expressions are admissible to vary the terms of the writing. Now you have 2 sections under here: the integration, final and complete expression. If incomplete, i.e. partial integration, evidence is admitted to supplement. The merger clause states agreement is complete on its face. Is evidence of the full integration. And then evidence outside the scope of the rule may be admitted under the circumstances A through D. A, evidence concerning validity, example, function defects, conditions precedent, evidence used to interpret words. Words are used are uncertain or ambiguous. Evidence showing true consideration paid. Evidence in action for reformation, meaning that something was not taken down correctly. I'm gonna come up. Oh, good boy. So you got gap fillers. If missing, Article 2 provides price, reasonable at time of delivery, place of delivery, seller's business, time of shipment, reasonable, time of payment, receipt of goods and assortment, buyer's option, delivery terms and risk of loss, non-carrier cases. Merchant seller, risk passes to buyer upon the taking physical possession. Non-merchant seller, risk passes on tender or delivery. So those are delivery terms and risk of loss. Carrier cases. Say hi, camera. Good boy. You all done? You all done, please? Okay, carrier cases. So you have shipment, the risk passes on delivery to carrier. Your destination, risk passes on tender at destination. And then FOB, risk passes on delivery to FOB location. Warranties and sales of goods. Types, title against infringement, merchantability, fitness, and express. So title, comma, against infringement. I haven't heard that one. And merchantability, fitness, and express warranties. Implied warranty and merchantability, goods are fit for ordinary purpose, implied in every contract by the merchant of goods of kind sold. Implied warranty of fitness for a particular purpose, implied whenever any seller has reason to know particular purpose for which goods to be used, and that buyer is relying on seller's skill and judgment to select goods, and buyer does in fact rely. Disclaimers. Title. Specific language or circumstances putting buyer on notice that seller is not claiming title. Merchantability. Specific disclaimer must mention merchantability, and if in writing must be conspicuous. B, also can be disclaimed by as is, refusal to examine or course of dealing. Fitness for particular purpose, only by conspicuous writing or general disclaimer, as is, refusal to examine, course of dealing, and express. Disclaimer usually not given effect. So those are 4 different kinds of disclaimers. Title, merchantability, fitness for a particular purpose, and express warranty. Now, the damages is the difference between the goods tendered and as warranted. Modification of terms. Common law. A, under a general contract, additional consideration is needed. The modern view permits modification without consideration of due to circumstances that were unanticipated by the parties when the contract was made, and it is fair and equitable. Written contract can be modified orally, even if contrary provision. UCC Article 2's modification section. No consideration needed so long as in good faith. Must be in writing as modified. Contract is for $500 or more, and gives effect to provisions prohibiting oral modification. So you need good faith, don't need consideration. You need a writing if it's for more than $500 by as modified, and gives effect provisions prohibiting oral modification. I don't know what that means. Part 5, has performance been excused or discharged? Has the condition precedent, concurrent, or subsequent been excused? There's 7 examples. Hindrance or failure to cooperate, breach of contract, anticipatory repudiation, party unequivocally indicates he will not perform before time of performance, prospective inability or unwillingness to perform, doubts he will not perform before time of performance, prospective inability or unwillingness to perform, doubts as to parties' performance, period. Okay, so I messed those up. They're related though. And substantial performance, divisibility of contract, and waiver or estoppel. So I like this list. I really like this list on this page. So I'm going to just hope this camera picks it up. Not happening. Has performance been excused or discharged? I already read that. Has the absolute duty been discharged? Performance or tenor of performance, occurrence of conditions subsequent, illegality of subject matter after contract was made, impossibility, impracticability, or frustration of purpose, rescission of contract, modification of contract, novation, replacing parties, or substitute of contract, replacing contract, accord and satisfaction. Have the terms of the contract been breached? Material or minor breach, common law, and perfect tender rule under UCC Article 2. Now, for material or minor, in a minor breach, the obligee gains the substantial benefit of bargain, so aggrieved party must perform but right to damages. Material breach, the obligee does not gain substantial benefit of bargain, so no duty to perform, immediate right to damages and other remedies. Perfect tender rule. If goods or delivery fail to conform to contract in any way, buyer generally may reject all, accept all, or accept any commercial units and reject the rest. What remedies are available if the contract has been breached? There's specific performance. If a legal remedy damages inadequate, court may order breaching party to perform land in rare or unique goods is when that may apply. For damages, damages can be recovered only to the extent they can be proved with reasonable certainty and could not be avoided with reasonable effort. Expectation damages, benefit of the bargain. Consequential damages available only if reasonably foreseeable. Liquidation damages if actual damage is difficult to calculate at the time of contracting. Amount is reasonable forecast of the likely damages, not punitive. Right, so that's how you define liquidation damages, is if they were difficult to calculate at the time of the contracting, the amount is not like punitive. Sale of good contracts, Article 2, there's different damages for buyers and sellers. A, buyer, one cover, difference between contract price and cost of replacement goods. Difference between B, difference between contract price and market price. 3, warranty damages if accepted non-conforming goods. And 4, consequential damages if seller knew a buyer's needs. Seller damages, difference between contract price and resale price. B, difference between contract price and market price. And 3rd, lost profits, your lost volume seller. Land sale contracts is the difference between the contract price and the fair market value. Employment contracts, employer breach is the full contract price. Employee breach is the cost of replacing employee. Construction contracts, breached by owner. There's 3 different phases. If it happens before construction, the builder's prospective profits are the damages. If during construction, contract price minus the cost of completion. If after completion, the full contract price plus interest. Breach by the builder, day or before or during construction, damages are the cost of completion plus compensation for delay. And 2, if the breach by the builder, late completion, right, is after completion, but the completion is late, then value of lost use is damages awarded to clearly the owner. Avoidable damages, non-breaching party has a duty to mitigate. Restitution prevents unjust enrichment. Measure is value of benefit conferred. Rescission and reformation. Rescission, contract voidable, rescinded if mutual mistake of material fact, unilateral mistake that other party knew or should have known of, or extreme hardship, misrepresentation of material factor, duress, undue influence, illegality, incapacity or failure of consideration. Reformation, writing change to conform to party's original intent if mutual mistake, unilateral mistake, and party knows of it and does not disclose, or misrepresentation. All right, so those are all the reasons why you could reform a contract, right? Is that the writing can be changed to conform to the party's original intent if there was a mutual mistake, a unilateral mistake, and the party who knew about it didn't disclose it, or a misrepresentation. Makes reformation available. Rescission, on the other hand, is that the contract is voidable or rescinded if there was a mutual mistake of material fact, unilateral mistake that the other party knew or should have known, or extreme hardship, misrepresentation of a material factor, duress, undue influence, illegality, incapacity, or failure of consideration. Now, the last part is going to be your third parties. rights and responsibilities under the contract. Third-party beneficiaries, only intended beneficiaries have rights under the contract. Vesting of third-party rights, no modification without third parties' consent after vesting. Third-party rights are vested if he manifested assent, brought suit to enforce the promise, or materially changed the position in justifiable reliance. Promisor can raise against the third party any defenses he could raise against a promisee. Third-party beneficiary versus promisee. If promisor fails to perform, you have two considerations here. For a donee beneficiary, they may not sue promisee unless detrimental reliance. The creditor beneficiary may sue promisee on underlying obligation. Third-party beneficiary may sue the promisor and promisee, but may obtain only one satisfaction. Two more sections here: assignment of rights, transfer of rights under contract, and delegation of duties, transfer of contractual duties. So this always gets covered last, and we're talking like 6 more parts. So for the assignment of rights, transfer of the rights under contract, 1, all contract rights are assignable unless assignment materially alters the obligor's duty or risk or is prohibited by law. Under this section, a contract provision prohibiting assignment bars only the delegation of duties. Revocability, part 2 under this section. Assignments for value are irrevocable, and this includes pre-existing debt. Assigner's warranty liability to assign. Assignor impliedly warrants when the assigner's warrants liability to assignee. Assigner's warranty liability to the assignee. Okay. In other words, the assignor impliedly warrants A, B, and C. A, he has made no prior assignment of the right. B, the right is not subject to limitation or defenses other than those disclosed or apparent. And C, he will do nothing to defeat or impair the right. Fourth and last, under the transfer of the rights, is the successive assignments of the same right, revocable assignments and irrevocable assignments. Within revocable assignments, the subsequent assignee prevails. In irrevocable assignments, a first assignee has priority. Last section, delegation of duties, transfer of contractual duties, duties that cannot be assigned. Those involving personal judgment or skill, those involving special trust in delegator, example, doctor and lawyer, and those restricted by contract. And lastly, those the performance of which by a delegate materially changes the obligee's expectancy. Liability of the parties. The delegator remains liable. The delegate liable if he assumes the duty and the assignment of contract or rights on the contract construed to include delegation and assumption of duties. So that's going to be it for the overview of contracts.